Hi guys, it's Taffy. I hope you're doing well. We made it to Monday morning. But at least it's not bright out like it was in the last stream. Thanks everyone who came out last night. I appreciate it. Now we're gonna have exes fighting. This will be fun, right? One's a teacher and I think one's a cop. Ex-cop? Maybe I'm wrong. Let's just go.
Good afternoon. Could you tell us your name and spell it for the record, please?
Christina Kuhl, Christina, last name Kuhl.
All right. And Ms. Cool, could you tell us what you do?
I'm a teacher, PE teacher.
Oh my gosh, guys. You won't believe who's in my chat. It's Belle. Belle. I can't find my It's Belle shirt. I bought, see what I wrote here? I made a shirt like that and bought it. I have it for sale on my merch page. And it's so soft and so comfortable. I packed up most of my clothes though, so I can move. So maybe it's in one of those bags, but I want to wear my It's Belle shirt. I gotta find it. Hi, Belle. Don't text and drive, okay? He's not going to say hi to everyone individually because he's texting and driving. I just got you in trouble.
And that's in El Paso County?
Yes.
And that school has security for it?
Yes. No, security cameras.
Security cameras. No armed guard or anything?
No.
And do you know someone by the name of Trent Austin?
No. V, thank you for the cheers. I appreciate it. Thank you.
I'm Austin.
I'm sorry. Shafit. Sorry. That's a typo.
Yes.
Shafit. Could you tell us how you know him?
He is my daughter's father.
Give us a little bit more context.
We were in a relationship for 2 years and we had a child together.
How long? When was that? That you were in the relationship?
We started dating in 2019. No, sorry. Hold on. To do some dates. 2020 until 2022. No, I'm sorry. 21 to 23. Because Eloise was born in 2022.
And how would you characterize your relationship with him today?
We do not speak.
Okay. Are you in any sort of legal process with him other than what we're doing today?
No, we already had a civil matter through the court and we have a memorandum of understanding in all of our civil matters and I have full custody of Eloise currently.
Okay. Backing up for a second, do you see Trent Shafit in the court today?
Yes,
Where is he?
right there.
You identify him by a piece of his clothing?
Purple shirt.
Does the reflect he identified the defendant?
Yes.
Could you talk a little bit about that memorandum? Does it have any relevance to the Talking Parents app?
Yes, the memorandum of understanding that was written after mediation states that we are to communicate through Talking Parents only about the minor child in a timely manner.
And what does that mean to you?
That means that I have to answer any and all messages that come through Talking Parents in regards to Eloise.
Okay. Can you talk a little bit about how Talking Parents works?
So I have the app on my phone. It is something that has to be downloaded and you have to pay for it. And the app works just like a regular text message. When a message comes through, it alerts you, it rings on my phone, it then rings a second time if I don't answer, and then I have notifications linked to my watch. And so I get notified on my phone, just like I would if I was getting a phone call or a text message.
There's an audible ring?
Yes.
And it rings repeatedly if you don't answer it?
Yes, it rings a second time if I don't answer.
And you said you have to respond to those messages in a timely way.
That's what the memorandum of understanding says.
Okay. And that's the case at all times, at night, during the day?
Yeah, the specific wordage, it doesn't say a specific time, but by all court orders that we've gone to, it's a timely matter.
Okay. So do those sometimes come in from the defendant at night?
Yes, while I'm sleeping, so I will answer them as soon as I wake up in the morning.
They sometimes wake you up?
Yes,
And does that process cause you stress?
extreme stress.
And it interrupts your sleep or other activities?
Yes,
Sometimes it interrupts your work?
very much so.
Got it. And when the defendant reaches out on talking parents, how often is it about your child care issues?
0% of the time within the last 6 months.
Okay. And have you raised that issue with him?
Nice streak, Granny, on Twitch. Nice streak.
I've raised that issue through my attorneys.
You've responded in real time, right?
Yes, and I've also raised the issue to him that the conversation needs to be about our daughter and our daughter only.
Gotcha. Okay. Specifically in police reports on this case, there's a period of time between 15th of December 2025, notably, not 26, and 30 January 2026, in which the defendant is alleged to have texted you quite often. Do you remember that?
Yes.
Do you remember how often he texted you?
There was one night where it was over 56 or 58 text messages within like a less than 24-hour period.
Gotcha.
And when I say text messages, messages on the app.
On that. Each of those causing a ring of your phone, at least one,
Yes,
and maybe multiple.
more than that.
Okay. And just briefly, can you describe the effects those text messages have on you in your own words?
It stresses me out. It spikes my anxiety. It causes me extreme headaches at times due to the stress.
Okay. And then more specifically, on January 29th and 30th, there was a series of text messages back and forth between you and Mr. Shafit. Do you recall that?
Yes.
Wow, V, thank you so much for the cheers. 1,000 cheers. Thank you. Thank you.
Do you recall there was a text about, and I apologize, but from the defendant about fucking someone named Andrew? Is that,
Yes.
you recall? Okay. And driving by his house?
He said I was driving by his house. Yes.
What does that mean? What do you mean?
In the message, it was saying that I just drove by his house in a car that I don't own. And as I was teaching a class, I was getting these messages and just said, I'm at work. I don't own that car. And it just kept going.
Do you remember a response in that time where you characterized him as delusional?
Yes.
Tell us why you characterized it that way.
I just felt like I needed a word to kind of stop it like that is delusional when you see things. So in my brain, from what I know, I said that you are being delusional because you're literally seeing things that are not happening.
And do you remember him talking about anything else to do with your workplace in those text messages?
Yeah, something super concerning, asking if I was not leaving work because somebody was not letting me, stating that he called the front office of my building and they said that I was not there, called my district superintendent where I work to report claims that I was stalking him, and we had a one-night stand. And so all those messages were coming through as I was at work.
Yeah. Gotcha. So potentially calling your supervisors?
Yes. I mean, the head of the school district.
The school district. Gotcha. And then do you remember a text on January 30th? That is, I believe, I think it was the next day at 10:20 a.m. where the defendant texted as part of this series of texts. Where is your gun? This has gotten out of hand.
Yes.
Could you tell us about getting that text message?
No, Bill.
So I was in the middle of teaching, and because I get the alerts on my phone was ringing constantly, going off, vibrating. My watch was going off. I keep these things on because I have a young daughter in daycare, and I need to have those readily available if there's an emergency. And so as I got that text message in the middle of class, I was highly concerned. So I had to immediately call for the front office to have somebody cover me so I could step outside of my office to calm down, because I immediately started crying, because that is concerning when somebody's asking you where your weapon is, to then get back on the phone and call the deputies about how I was feeling at that time.
Sorry, call the deputies.
This is where she should stop. This is where her lawyer should stop, right here. They did enough. Now they're going to make it worse. But I got it fixed. My car runs fine now. Yep.
I had to call
Spare's still flat.
had been talking to a previous deputy the night before when I got those multiple messages. I think it was 56 or 58 plus messages. And so that deputy might not have been working that morning. So I called back the non-emergency line at the point asking for an immediate call back from another deputy. And at that time, they wound up getting the deputy calling me, a different deputy right away.
Okay. So you immediately called the police is what I understand.
Yeah, sorry.
And no, I just want to make sure I understand. And can you describe what exactly concerned you about that text message? Where is your gun? This has gotten out of hand.
In my head, why would somebody be asking me where my gun was if they weren't coming to do something to hurt me? So why would I need a gun to defend myself, or if somebody wasn't coming to do something to harm me?
And do you recall, 27 minutes later, the next text that came in from the defendant read, are you at school today and not leaving without permission?
Yeah, that then became even more concerning because that's the time that I leave for work. So I usually leave, my lunch and plan time is 10:45 to about 12:15. And so I leave work for just to get out of the building, to run an errand, to take care of the things that I do, go to the gym. And so that coming in at 10:47 was extremely concerning because I leave around 10:45. So asking if I wasn't leaving also made me highly concerned.
Because what was the conclusion you drew from that?
That somebody was watching me. He was outside. He had somebody else outside watching me, seeing if I was leaving to follow me.
Gotcha. And you said you called the police in response to these texts?
Yes.
What else did you do in response to them?
I did not leave the building at that time because I was scared somebody was going to follow me in a different truck. I made calls to my family to advise them at what was going on so that they knew I would be safe. That's what I did that day. Moving forward, I changed my routine. So I didn't leave at that exact time. I went out a different door. I go a different route when I go to a gym now. And so I've changed all the things that I do just to make sure nobody's following me out of the building.
And did the defendant ever try to reassure you or tell you in any way that these weren't meant as a threat? Or I'll you answer that.
After those text messages, I believe, and a lot of these messages have really caused harm to my mental health. So some of it I just might need reminding. But later on in that day, at some point, the messages had stopped after he had then said he called my superintendent of my school district and that he called my direct supervisor at my job. And so he never said he was going to stop, and these weren't threats. He just continued about that, and I never answered.
So he never told you this was a joke, or
No,
that he wasn't watching you,
no,
or that his comments about a gun weren't
no,
relevant in any way?
no.
Do you still feel threatened by the defendant today?
Yes,
Do you still use the Talking Parents app?
not currently because there's a no contact order.
Thank you.
Mr. Lux?
Yes, Judge. The no contact order you're referring to, Ms. Cool, right?
Yes,
That's from this case, right?
correct.
Okay. There's not an active civil protection order in place that prevents Mr. Shofit from contacting you?
The civil protection order is through this case.
There's a criminal protection order, right?
Yes, so there's
Yeah.
no longer a civil, no.
Yeah, you had a civil protection order at one point. I think there was like an agreement to dismiss it after a year, but that had been dismissed long before these charges occurred, right?
Yes,
Okay. And so what you're talking about regarding the way that you and Mr. Shofit communicate is based on an agreement out of a domestic relations case, which says that you're supposed to use Talking Parents to communicate about your shared child, right?
yes,
Okay. Now, I guess one of the things that you mentioned is like, well, I have to respond within reasonable time to these messages that he sends me, right?
yes,
Okay, but your requirement to respond is about messages that are sent regarding your shared child, right?
the wording states that communication must be about the minor child only.
Right. And so you're saying I'm required to respond. You're only required to respond to those communications concerning the minor child, right? So if he messages about you something completely irrelevant, you don't have to respond to that.
I do have to not leave them read per the under order of my attorney. I have to at least respond with, this is not in regards to Eloise. So yes, I do have to, per my attorney, because I've had
Her order says she has to reply to all messages timely. All.
conversations with my attorney about that before.
Judge, I'm going to ask the court to take judicial notice of 2023 DR 1977. Ms. Cool, does that sound like your domestic relations case number?
Sounds familiar. I don't have it in front of me though.
All right. And then I'm looking, Judge, at a order adopting a memorandum of understanding from May 17th of 2024. It looks like the memorandum of understanding was from May 16th of 2024, and Exhibit A would be the MOU. Is the court able to pull that up?
Yes.
And can the court take judicial notice on the language concerning Talking Parents?
Let me. I have memorandum of understanding permanent orders, May 16th of 2024. Section 1 has allocation of parental responsibilities, the schedule. Is it in this memorandum or is there a second part that I'm missing?
It should be in that memorandum. It's showing as suppressed on my end.
Oh,
I
okay.
can see that it's there. I just can't read the actual terms.
All right, give me just a moment to look through this.
I have it on me if you need it.
Judge. Just a moment, because it'd be better for me to get it from here. Stipulation.
Quit your job, Margaret. Quit your job.
Oh, there it is. It's within allocation of parental responsibilities. So I'll take judicial notice of 23 DR 1977, specifically this memorandum of understanding. The language says the parties will communicate via Talking Parents and will limit communication to child-related issues only. All messages will be responded to in a timely manner.
All messages will be responded to in a timely manner. Dude, you should have read that a little bit before you told the court to read it.
Communication will be civil in nature. When petitioner makes a major decision for the child, she will notify respondent of same. That's the language.
Okay, so we got language saying the communications regarding your shared children, and those messages need to be responded within a timely manner, correct? Okay. All right. Now, I guess I want to get the time right. So you're saying there was one point where my client sent you 56 messages in an evening,
In a 24-hour period.
24-hour period. Okay, what day was that?
I'd have to look at my phone. I don't remember exactly. It was the first day that
Was it the day you called the police?
the first time, yes.
Okay, and so who'd you speak with on that day? Was it Deputy Bates, or it was Deputy Bates?
Yes.
Okay, so would that have been on January 30th of 2026?
Yes. I believe so. I don't have the paperwork in front of me. Yes.
Yes.
Oh, sorry.
Well, thank you also.
I don't know what, sorry.
right.
So I'm just showing you Deputy Bates's report. It looks like he cites 1/30/2026 as the date he was contacted by you. Does that sound accurate? Or maybe the day he called you back?
That probably. Yeah, so this day on the 30th, I would have to have my phone in front of me to to answer 100% accurately.
All right, well, fair enough. You provided officers, I don't know if it was Deputy Bates or if it was Deputy Heskes. Does that sound like her last name?
Yeah, that was the initial call in December,
Okay.
if I have that right.
All right. I believe you provided Deputy Bates with a number of screenshots of the messages that you're
Yes.
referring to, correct?
Yes.
Okay. Let me just hand this to you.
Yeah, that's fine.
Just so you know, if you ever text me, my timely manner of responding to texts is like 3 weeks, maybe.
See,
Right, Bill?
you want to flip through that? Let me know if those
No,
are the
I'm sorry.
screenshots that you were provided with. That's the one that you filed. Yeah. Same thing you got?
Yes.
Okay. So that's fair and accurate depiction of what you provided?
Yep.
Those screenshots include those 56 messages you're talking about?
They include some of them, I think.
Okay.
As I said, I would have to pull up the app on my phone.
All right. So, Talking Parents generates a transcript of all the message exchanges between you and Mr. Shaffet.
Mm-hmm.
Okay, and you can download that and get a certified copy of that?
Yeah, and we were trying to get the exhibit to the officers, but the app was not because all the messages were so big, it was unable to email to the officers. So that's why I provided with screenshots.
Okay, well, in Exhibit C, it doesn't include 56 messages sent without a response, right?
Not with what was provided to the deputy.
Okay. And so your testimony is that when these messages came through, your phone both emitted a noise and vibrated?
Yes.
Okay, and it would emit a second noise if it wasn't answered?
Yes, it's an alert. Like the second time that a message comes through, if you don't answer right away, it dings about 30 seconds later or a minute later. I don't know the exact timing.
Okay. And and then you said it also causes your Apple Watch to vibrate?
It's a Garmin, but yes.
Garmin to vibrate? Okay. You can toggle that setting on and off in your, your app settings on your phone?
It's not really an option to do that when I'm having to answer in a timely manner.
Well, you had done that before, right? You'd turned the notifications off previously?
No.
See, you should have stuck with, I have to keep my phone on. I have a child in daycare.
You didn't tell Deputy Bates during your phone conversation with him on the 30th that you had
Yes.
turned the
That was
notifications
here.
from Mr. Shaffet off before?
Maybe at the beginning, when we first, the notification to alert on my phone.
I don't know. I guess my question is, did you tell Deputy Bates that you had turn those notifications off previously?
That was in related to asking if I could shut the app off. So I could silence my phone like at nighttime if I'm sleeping
Is that
But-
what you did?
some days.
Okay. Well, the period we're talking about is from December 15th through February 4th.
No, this was at other points when Mr. Shofit had continued to use the Talking Parent app for other means.
Okay. So during this entire period from December 15th through February 4th, you had those notifications enabled.
Turned on, yes.
Okay. So it was vibrating your phone, making an audible noise, and also vibrating your wristwatch when those notifications came through.
Yes.
Okay. Now, what we're talking about is messages sent through the app, right? Not phone calls.
There was a phone call
When was the phone call?
when he was talking about, I don't want to even use the language out loud, but he was using a curse word, INGing a person. He told me that he was calling me to tell me that he was telling someone that I did that
When was the phone call?
within those days. I don't remember exactly. I don't have my phone in front of me.
Was that a call that you
Through
answered?
the Talking Parent app.
Was that a call that you answered and spoke to him?
He was going on about it and then
I do. I put every single one of my streams in Discord. They're in the channel called Kathy's Video. Every time I go live, I put it up there, so it's supposed to notify. Supposed to.
I asked him what he was calling about. And then that's when he said in the messages, I was calling about you, FUCKINGing Andrew.
Okay, but that was a phone call you answered?
I don't remember if I answered that one or not, honestly.
Okay. Did you respond?
I don't have it in front of me, so I wouldn't know.
Okay. Do you recall listening to that message as a voicemail?
Those were text messages in the app.
No, I'm talking about the phone call.
So on the Talking Parents app, the phone call comes in.
Mhm.
I'm not honestly sure if you can leave a voicemail. I don't think he ever has.
Okay.
Terry, are you in Discord by any chance?
So if he's never left a voicemail before,
I
that's
mean,
probably a
at
call
all,
that you
not
answered.
right this second.
Hey,
I'm not.
Mr. Klinowski, I'm going to ask the court to have Mr. Klinowski not comment on the testimony.
I think we.
All right. So I guess my question was, if he's never left a voice message on the app before and you received information from him from a phone call, that's probably a phone call you answered, right?
I honestly, as I stated earlier, like my mental health and this situation back and forth has done a lot to my mental health. So I can't tell you accurately without being with the app in front of me if I answered or not.
Okay. All that information is still contained within the app.
Yes.
So those are things like you can double check.
Yes.
Okay. Understood. The two messages that we're talking about during that last exchange, where is your gun? This has gotten out of hand. And are you at school today not leaving without permission, right?
Yes.
Okay. And so in those messages, Mr. Shofit never says that he has a gun, right?
No,
Okay.
he shouldn't have a gun anyways.
Sure. Okay. So shouldn't have a gun. He never says that he did have a gun, right?
Shouldn't have a gun and having a gun are very different things.
Okay. He doesn't say that he's going to harm you in any way, correct?
It's implied harm.
Well, you took it as implied harm, right?
Yes.
Okay. The comment, are you at school today and not leaving without permission? He doesn't say he's at the school, right?
But to any reasonable person, why would someone want to know if I was leaving school or not?
That's the way you took it, right? But that's not what he said.
He asked me if I was not leaving school
Okay.
without permission.
He didn't say he's going to come to the school?
I don't know if he was at the school.
He didn't tell you you cannot leave the school.
No.
Okay. There's no threat of violence there either, right?
I'm taking it as a threat of violence.
Yeah, you took it as a threat of
Yeah,
violence, but
me
the actual
too, sir.
message didn't include any threat to harm you, correct?
Ooh,
Okay.
Mm.
I believe those are my questions, Judge.
Did the witness actually answer that question? I don't know what that.
Oh, I thought that was a,
It appeared to be an answer of some sort. Do you have any redirect?
Just briefly, from the discussion that we just had about the MOU, I believe the language was all messages will be responded to in a timely manner. Was that
Yes.
correct? And that's how you took that
yes.
MOU. You responded to all messages.
Yes, I've had conversations with my attorney about how I respond when the messages are not related to our daughter, and I was told that I still needed to respond that this is not related to my daughter. That is not true, or else if I'm not saying anything, it could be seen as an admission of guilt of something.
Understood. Okay. And even if the messages are not about a shared child, are you okay? Do you need a moment?
No, I'm okay. Sorry.
If the messages are not about a shared child, how do you know if that's the case?
It would be related to our daughter. Like the only thing that would be related to our daughter is about if he had completed his process that he has to.
But to know if a particular message is about the daughter or not, you have to read that message. Correct?
Yes, sorry. Yes.
No, you have to read it.
I'd have to read it.
So even if you don't respond, each message, whether about a daughter or not, still takes your time and attention.
Yes, because I need to know if it's related to her and I have to respond.
All right, who in chat had the most swatch bands? Swatch watches? Yeah, you could change the wristband to different colors. Who in here had the most colors as a child? I didn't have a swatch watch, so I did not.
Thank you. No further question.
I just have a couple. And I'm sorry, tell me again how to pronounce your last name.
Cool.
Cole.
Yeah.
Thank you. Miss Cole, you said you're a teacher, is that right?
Yes.
E.
Yes.
And what are your work hours during the school year?
7:50 to 3:50. And then my lunch and plan time, like where I'm free and don't have children with me, is 10:45 to 12:15.
The memorandum of understanding does say you're supposed to respond within, I think it says in a timely manner.
Yes.
Is the language. You interpret that to mean that even if you're in the middle of teaching a class, you have to respond right away?
I interpret it that if it's coming through the Talking Parent app, it's something that I think I need to answer. Because I don't want to get in trouble for not answering something. I don't want something to go back on to me that like I didn't answer this or I didn't respond to this when I needed to. So when it comes to the Talking Parent app, I answer as soon as I get the messages because I don't want to get in trouble for have that used against me. Like I didn't answer in a timely manner.
Okay, I understood that. Thank you. Okay, give me just a moment to look through my notes, okay?
Did the judge just tell her she doesn't need to worry about court orders in the middle of class? No, she doesn't need to answer in the middle of class, but it still dings in the middle of class and then notifies her in the middle of class. What are you talking about, Bill? They're not interrogating the man at all. Or pay attention. Bill, you ever hear that before? Pay attention.
Did either counsel need to ask any additional questions based upon my question?
There you are. Judge.
Okay. Ms. Cole, thank you so much for your testimony. You can go ahead and step
Lacey.
down, okay? Steve, were you calling in?
Yes, just briefly, Officer Bates.
Okay.
She left. Look, she's not hanging around to hear the verdict or anything. She just left. She's like, I'm done here. Every night.
You'll come in front of me. I'll swear you in, sir. Do you solemnly swear or affirm under penalty of perjury the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead and have a seat, sir.
Good afternoon.
Sir,
Could you state your name and spell it for the record, please?
Deputy Jason Bates, Jason Bates.
Could you briefly tell us your profession?
I am a sheriff's deputy with the El Paso County Sheriff's Office.
And how long have you done that job?
Currently with this organization, 13 years.
Okay. And do you remember responding to a call to service in late January of 2026 for Miss Cool?
I do.
Can you tell us about that?
I actually took the call by phone. I was in a modified duty position. She told me that she was receiving numerous unwanted texts via the Talking Parent app. There was vague statements that she was being tracked and or followed. There were statements questioning whether she had her gun or not, which caused her to be afraid. She stated that she was afraid to go to work, afraid to go to the gym, to live her normal life due to apparently being stalked by someone that claimed to know her whereabouts at all times or alluded to that. There were threats of using law enforcement resources to verify her locations. I don't remember all the texts, but that was a summary of them.
And that was your initial reporting by phone with her?
Yes.
What happened after that?
She sent me screenshots of all the texts. It was through the Talking Parents app, which I believe creates a permanent record, which is also supposed to be used only for issues dealing with the children.
Gotcha. And how would you characterize her level of concern? I think you just started to describe it when she talked to you.
She felt in fear.
And what was your reaction to the text messages as you reviewed them?
It appeared as though they were threatening messages.
Why do you say that?
The hostility and the tone of the text saying,
Hey, Raven.
I know where you're at. You're lying about where you're at. I know you were here. One of them, I think he said he threatened to use FPD to verify her phone location, something like that. Another deputy that was actually in the field attempted to contact him or did contact him. And she said that he was either highly intoxicated or on something, I believe was.
Why would that cause more concern? Or would it cause more concern?
Because of the poor decision making that's
Got it.
while you're intoxicated.
Okay, so what did you do in response to this information?
I documented the information. I conferred with supervisors. They said that it fit the elements of stalking statute. I wrote a warrant. I presented that to a judge or magistrate here at the courthouse. They agreed and signed off on the warrant.
Okay. And do you remember a specific text that read, "Where is your gun? This has gotten out of hand"? after a series of other texts?
I do remember that one, yes.
How would you characterize that text in terms of its nature?
It sounded to me as though they were trying to verify whether or not you were armed and what kind of opposition they might face if they approached you.
And why is that a concern?
Because that's not something that should be talked over the Talking Parents app in the first place, which is strictly for the child. And if somebody's asking me if I have my gun or not, I want to know why. Well, what is their reason for wanting to know?
What would you infer might be the reason?
They would want to know if I was unarmed and an easy victim.
And do you remember the text that followed that said, "Are you at school today and not leaving without permission?"
There were, I don't remember all the texts. There were quite a few of them. I think over 80, close to 90 texts over a period of a few days.
Gotcha. And are you familiar with Sand Creek Elementary School?
I vaguely, yeah.
Are you aware that's where Miss Cool works?
Yes.
And are you aware that's where she was when she was getting these texts?
Yeah, she said she was at school hours. She was getting texts during work hours. One of the texts, the first text she sent me, she literally says, "Leave me alone."
Mm-hmm.
And the text continued.
Mm-hmm.
Oh my gosh, Terry, you look gorgeous in blue. Yes, you do. Welcome aboard. Terry's our new mod, guys.
And obviously, as a law enforcement officer, violence and mention of weapons in relation to schools is a special concern.
Very much so, yes.
Is there anything else you did in relation to these texts after getting probable cause for stalking?
I cataloged them in a digital evidence file, which is accessible to the courts.
And from the texting that you saw, would you would you conclude that those were threats to Mrs. Cool?
Yes, I would feel that way.
Thank you.
Thank you. Mr. Lux?
Deputy Bates, handful of follow-up questions for you. The text messages that you received, that you made a statement that there were like 80 texts over a couple days. Did you receive 80 text messages from Miss Cool?
I received numerous screenshots that contained multiple texts.
Okay. All right. You didn't count them, check how many there were.
She told me the number.
Okay. So that's probably coming from her rather than you going through and checking
Yeah,
messages. You said Talking Parents is an app that tracks everything that's said on the platform, right?
I believe it is.
Okay. And you can get like a transcript of that and view when a message was sent, when it was received, when it was viewed.
That was my understanding.
But you didn't get the actual transcript of the Talking Parents messages, right? You got just screenshots that Miss Cool took and sent to you.
Yes.
Okay. Who spoke to Mr. Shoffett?
Deputy Keskis, I believe is how you say her name.
Okay. You know what she talked to him about?
No, she said she attempted to call him to locate him and possibly meet with him, if I remember correctly, but he was highly intoxicated and she could not get definite information.
You know, she made the determination that she was highly intoxicated from meeting him in person or just talking to him on the phone?
Just through trying to have a normal conversation
In person or on the phone?
on the phone.
Okay. So you don't know what Mr. Shoffett said he meant by those messages? If he made any statement regarding those messages?
As far as did he send the messages or what?
No, I'm sorry. Like, you don't know the substance of any conversation between Deputy Keskis, between Deputy Keskis and Mr. Shoffett about what he meant by the messages that the DA referred to regarding, do you have your gun and are you leaving school?
I don't know what he meant. I
Sure.
know what she inferred.
Yeah, and you don't know any statements that my client made regarding those messages?
Other than she perceived them as a threat.
Yeah, I'm sorry. I'm talking about any statements that my client made about that, not what other people interpreted.
We attempted to contact him, but like I said, it was
Understood. What day did you speak with Miss Cool?
I do not have my report in front of me.
Miss Cool ever make any statements about receiving any phone calls from Mr. Shoffett?
It would be in my report.
Okay. Do you want to,
Case.
I believe I got a copy of that. Do you want to take a look?
Sure.
Yes.
Hand that to you and feel free to take possession, flip through it. And then I'm showing him exhibit A.
I see that. I put that he sent her text messages on Talking Parents and was also threatening to contact her supervisors at Sand Creek Elementary.
Okay. So the threat presumably came from messages and talking parents as well.
Yes,
May I retrieve that binder?
yes.
Thank you, sir. How did she, so you established that she got the messages through talking parents. Did you have a conversation with her about like how she knew she got a message? Like, how did it come through? Was it, just a text message? Was it a text message that came through with an alert? Did her phone vibrate? Did it ring?
I
Talk
don't
about
know
it.
how her phone operates.
Did you ask any questions about that?
She just said she was trying to work and was continuously getting texts.
Do you recall having a conversation with her where she stated that she had, I guess at one point, like turned off notifications from the Talking Parents app?
I don't recall that, but being as that's pertinent to the interest of the child, I don't think she would turn that off.
Okay, so you don't recall her making that statement and saying that she'd turned off any notifications?
Usually what I advise is people to try blocking someone first if it's through normal text.
Mm-hmm.
But being as it is a text message specifically for the care and well-being of a child, I don't recommend that.
Okay. Well, you specifically told her to like keep getting those messages because they would be helpful for applying for a protection order, right?
I may have if she needed protection order.
Yeah, you said there'd be relevant proof for it, right?
Right.
Okay. And she stated that she didn't want to, I guess, expend the cost to obtain a protection order
I don't believe there's any costs involved.
for lawyer fees.
My understanding, anyone can apply for that.
Yeah, that's the response you gave to her, right? Is like, well, you can go and take one of these out yourself. You don't have to have a lawyer.
If I did, I don't recall saying that.
Okay.
I have that conversation on a nightly basis.
Okay. You would have had your body worn camera on during this telephone conversation.
It would have recorded my audio.
Okay. Understood. You charged my client with stalking, right?
Yes.
You didn't charge him with harassment?
No,
Why not?
because it fit the elements of stalking.
Did it fit the elements of harassment?
Could have, but it went beyond that into the realm of stalking.
Okay. Well, you can charge multiple charges.
Right.
Okay. Any reason you didn't charge any of the harassment subsections?
Stalking covered what I needed.
Bigger charge?
I'm not one to stack charges.
Okay. Understood. I think those are my questions, sir. Thank you very much for your time.
All right, sir.
Thank you so much for your testimony. And is Deputy Bates free to go?
He is young.
Thank you. You're all set.
Thank you.
Asking anything else?
No, just, we appreciate the opportunity to lay the factual context for the case.
Mr. Lux, anything other than argument?
I'm happy to proceed the argument, Judge.
Okay.
So I guess first I'd state, I'm happy that the DA facilitated those, that additional evidence. I think that certainly provides some context and helps clarify some aspects to the case. Judge, at this stage, given the procedural posture we're in, I'm not asking the court to weigh credibility. I don't think it's properly at issue before the court on a 12B motion. What we're asking for the court to do is determine whether text or app-based talking parents messages can actually satisfy 189-111-1F, which criminalizes making a telephone call or causing a telephone to ring repeatedly. Those are the words of the statute. And next, we're asking the court to determine whether the two statements that are identify the people in their bill of particulars constitutes a true threat under the First Amendment after Counterman versus Colorado, as the court cited 600 U.S. 66 out of 2023. I believe that both issues are appropriate for a pretrial resolution under Criminal Procedure 12B because they're capable of being determined without trial of the general issue. I point to Moreno itself as support for that, which was a pretrial dismissal of a harassment charge involving electronic communications under 1E, and the Colorado Supreme Court affirmed that from that pretrial dismissal. We accept the burden of proof. It's definitely on my side on this motion. We do have to prove that the statute would be unconstitutional if applied to the facts in Mr. Shafit's case, and our burden is proof beyond a reasonable doubt. Accepting that burden, I guess what I'd point out is that does not allow the court to presume that ambiguous speech is unprotected. That's clearly established under First Amendment precedent, nor does it relieve the prosecution of their requirement to satisfy counterman. I'll start with count one. I think that's the cleanest issue here. Under 18-9-111-1F, we're looking at a person committing harassment if they make a telephone call or cause the telephone to ring repeatedly, whether or not a conversation ensues with no purpose of legitimate communication. I'd argue, Judge, that the wording there is significant. People are not alleging that Mr. Shafit placed telephone calls, I guess with the exception of that one statement made by Ms. Kuhl that she received a telephone call from Ms. Shafit. I guess it's not clear if that is a disputed point of fact because I don't know if she gave a firm answer on that. She says that she received information from Ms. Shafit, was not clear if this was I think what is undisputed is this was one call during the period that's charged by the district attorney. I guess it is not clear whether or not that was a voicemail or an actual conversation. So I'll just leave that there. But she's not alleging any hang-up calls, any repeated dialing of her phone. As far as, I guess, the communications, they're just alleging these talking parents' messages caused her phone to alert with a ring. I'd argue, Judge, that an app alert's not the same thing as a telephone call or telephone repeated ringing. 1F is written in the language of telephone calls, makes a telephone call, causes a telephone to ring repeatedly, whether or not a conversation ensues. I think that language makes sense in the context of a call. It doesn't naturally describe stored electronic messages, text alerts, push notifications, or app-based messages. And I think the structure of 18-9-111 confirms that. 1E expressly covers communications by telephone, telephone network, data network, text message, instant message, computer network, computer system, or other interactive electronic medium. 1F does not. Clearly, the legislature knows how to write electronic communications sections as it distinguishes between 1E and 1F. And it did that in 1E. It doesn't include that language in 1F. And I think the court, my initial motion included a little bit of legislative history there about how 1E had existed, was later amended, and 1F was not amended concordant with that to expand the language to include messages over any kind of data network. So the people in their response argues that our reading makes the language, causes telephone to ring repeatedly meaningless. I'd argue it doesn't. The phrase covers repeated dialing, hang-up calls, automated calls, third-party calls, or any other conduct that causes a phone to ring as a phone. It specifically says ring, not alert. What it does not cover is every text message, app notification, email alert, social media chime, or any digital notification that makes a sound. I think a really good case on point here is Weeks that deals specifically with the 1F subsection in Weeks involves an actual telephone call in the call context, explains why ringing a telephone is uniquely intrusive, because ringing a phone demands an immediate answer. It doesn't hold that an app notification text alert equals a statutory ringing under 1F. I'd say if anything, Weeks supports the defense's distinction that a telephone call is immediate and imperative. Text or app communication can be muted, ignored, deleted, blocked, or reviewed later. This is a criminal statute, so if the court believes that the phrase causes a telephone to ring repeatedly is ambiguous as applied to app alerts, lenity applies. Believe we laid that out in our motion, the case law supporting the rule of lenity. So the court should not expand criminal liability by analogy to modern technology where the legislature addressed that technology in another section. And for those reasons, I'd ask that count 1 be dismissed. I guess I'd also note that in my extensive research on this issue, I believe the people's extensive research on this issue, and maybe the court can tell me if your research has turned up anything else, I cannot find any published case law on point for, text alerts. And so I guess the court gets to act as a bit of an appellate judge in this situation in kind of broaching it.
Lacey, thank you for 22 months. I appreciate it. Thank you.
Area that I may not be new in the context of these motions raised in county court cases, but certainly is new, to me in reviewing the published authority on the matter. Turning to count two, I appreciate the people's response to the bill, particularly. I think that's incredibly helpful because I do think we have to look at the actual messages that they are saying constitute true threats. And in the response, they identify 2 communications: "Where's your gun? This has gotten out of hand." And a second message: "Are you at school today?" and "not leaving without permission." The people say that those 2 statements, made 27 minutes apart, suggest bodily injury because they refer to a gun, some kind of loss of control, Miss Cool's location, and her departure from work. The bill of particulars also says that this communication results in annoyance or alarm. I kind of go back to Moreno on this one, and it might be worth another look. What I see in Moreno obfuscated the language with intent to harass, and then goes on to say that it left intact the sections that pertain to threats of bodily injury or property damage. I don't see them leaving intact the language annoy or alarm.
Thank you for the bit.
So I believe those are gone
Thank
from
you, V.
what can be
The
used
chair.
to support a
The chair.
conviction under that statute. People also concede that obscenity is not an issue, so I don't think we're talking about a claim of obscenity anymore, just the through. Sorry? Oh, you're agreeing? Okay. Wait,
I apologize.
you're welcome to interrupt me with
No,
agreement
no.
at any point.
He is agreeing with
So it's just the true threat provisions. So, turning to then the true threat analysis. So a true threat is a serious expression conveying that the speaker means to commit an act of unlawful violence.
I wish the other attorney could ask this lawyer one question. What? What if he was sending the lawyer's wife these messages? Then how would this lawyer feel?
That's Virginia versus Black.
Or his daughter?
And after the Supreme Court counterman case, the state has to prove more than objective fear. The Supreme Court held that the state must prove that the defendant had some subjective understanding under a mental state of at least
Hi,
recklessness
Kelly.
of the threatening nature of the statement. So the true threat inquiry has 2 parts. Communication is objectively a serious expression of an intent to commit unlawful violence, and did the defendant act with at least recklessness as to the threatening character of that communication. And that's the Supreme Court standard, and
We're waiting with you, Crystal. We're all here waiting with you.
the actual charge statutes here that mental state is with intent. The 2 statements in the bill of particulars don't satisfy that standard. First statement asks, "Where's your gun? This has gotten out of hand." Clearly a question. It does not say that Mr. Shafet has a gun. It does not say that he is coming to harm Miss Cool or even coming to Miss Cool's presence. It does not say that he will use a gun. It does not say that he will harm anyone. It asks where the gun is and says that the situation has gotten out of hand. The second statement asks, "Are you at school today?" and "not leaving without permission." does not say that he's at the school. It does not say that he is watching her at the school or watching the school itself. It does not say that he'll come to the school. It does not tell her that she may not leave. It does not threaten violence if she does leave. People's theory requires inferences stacked on inferences. A question about a gun becomes a promise of violence. A question about school becomes a workplace threat. A reference to permission becomes a threat about leaving for lunch. Later alleged non-cooperation becomes consciousness of guilt, and I'd argue, Judge, that that's not enough. While the court can consider context, counterman is the controlling federal constitutional floor and requires at least recklessness and a threatening character of communication. Recipient fear may be relevant, but is not dispositive. People also rely on this later allegation of intoxication, disorganized thought, or non-cooperation during this telephone call that Mr. Shafet had with another deputy. But that later non-cooperation doesn't change the words in the charge communications. A failure to explain oneself to law enforcement is not a threat, nor is it required, and it cannot supply the missing statement of unlawful violence. Judge, most of these are ambiguous questions in the context of a contentious relationship dispute. Ambiguous speech does not become a true threat because the recipient felt fear. The First Amendment requires breathing space for protected speech, and counterman exists precisely because objective alarm is not enough. Therefore, count 2 should be dismissed. And in our reply, we did reference the bill of particulars. And so I guess just to bookend that response, our argument in our reply was that the bill of particulars should be deemed binding and exhaustive. I believe the people in their bill of particulars response stated that that was a non-exhaustive statement of the charges. The bill of particulars forecasts the facts that the prosecution intends to prove and limits proof at trial to those areas. The people cannot introduce 2 statements, but then preserve a non-exhaustive universe of other statements. That defeats the point of the bill of particulars. So I'd ask the court analyze this motion under the response provided by the people in their bill of particulars. I think that's all for me, Judge, unless the court has any questions.
No, I just referencing that phone call
Yes.
testimony. I'm looking at exhibit. Let's see which one.
Is it C?
I think it's C.
Yeah.
It's appeared on D. So on the top of one of the pages,
Page 3?
7, yeah.
Mm-hmm.
So, and Ms. Cool did testify to that briefly. She said, what were you calling in reference to? And then there are texts about that.
Okay.
So I think that's the only testimony I heard with regards to a phone call, that there had been a phone call.
Sure.
She did not speak to him and then was asking, what were you calling in reference to?
Fair enough, Judge. And I guess,
But I'm not sure it matters a whole lot. It's one phone call in the context of everything else. But I just wanted,
yeah, and I guess
it's the only thing I understood in terms of the testimony regarding a phone call.
I agree with you, Judge. And again, that we got to take all the facts in light most favorable to the people at this stage. So assuming that there was a phone call, that it was not answered, and that she then sent this message in response, what were you calling in reference to, that is one phone call. And I think that's where it distinguishes it from 1F, where we're talking about repeatedly making a telephone ring. I think it is undisputed from her testimony and from the evidence we have in this case that there was one phone call, just one. So,
Yeah.
okay.
Thank you. Mr. Klonowski?
Yes, Your Honor, I'll try to narrow myself down and be brief in response. I appreciate everyone's time late in the afternoon. Just a few points specifically from what we just heard, of course, in reference to ambiguous speech. We had the helpful testimony in terms of the 2 texts at issue from both the subject and recipient of them, as well as law enforcement as a neutral observer. Both of them understood, even if inferentially and reading the context, that those messages were threatening. And I agree with the defense counsel. He said wording is significant. although he very artfully
I am feeding you. I'm feeding you knowledge of the lawyers. Knowledge.
tried to use different words for what's happening with the victim's phone in this case, chiming, alerting, etc. The victim described it as a ring, both on her phone, and then she said following up on her watch as well. That is the wording of the statute. Looking very briefly at 1E and 1F, I do agree with a lot of the analysis of case law provided by defense counsel about the history of specifically Criminal Code 189-111F that focuses for the most part on telephone calls in its history. However, obviously, the times have changed and technology changes. Looking at the wording of the statute, that wording is significant, and it specifically pulls apart two different things, which is making a telephone call, notably a telephone call in the singular, which seems to be pertinent in this case all of a sudden, or causing a telephone to ring repeatedly with no legitimate purpose of conversation. Those are two different things and should be looked at differently. The fact that 1E and 1F have been changed over time and maybe redundant in some ways doesn't undermine or allow us to ignore the wording in either particular statute. For example, both 1E and 1F talks about using a telephone to cause the required harassment, telephone network in 1E or telephone call in 1F. It's perfectly possible to violate either provision with the statute. Similarly, I think the use of text message in one subsection and the use of causing a telephone to ring repeatedly in another section doesn't undermine the fact that you can potentially implicate both with the same act. And I do agree with defense counsel specifically on the importance in looking at the issue of 1F for the importance of talking parents in this situation specifically. If I may, Weeks talks specifically about the gravamen of the offense in harassment telephone is the thrusting of an offensive and unwanted communication on one who is unable to ignore it. A ringing telephone is an imperative which in the minds of many must be obeyed with prompt answer. And that's at Weeks, page 96. That's especially true of Ms. Cool in this case, and I think it differentiates a great deal from other cases that might be analyzed with text messages or a Facebook message or an email, where Colorado courts have mostly focused on 1E for those electronic communications, but
Americans can't say that word.
here, with the Talking Parents app, Ms. Cool understood, as we heard, that she was required to respond in a timely way, and that these communications, specifically for their deleterious effect on her and her mental health,
Ouch,
meet
that
exactly
sounds
the intent
painful.
of 1F. They would come at night in class, and she understood that they required monitoring and response in the same way that Weeks talks about a telephone call being different and worthy of special protection. I think that using a little bit of the defense counsel's statute, that a penal statute must define an offense with sufficient clarity to permit ordinary people to understand the conduct that is prohibited and in such a manner that does not encourage arbitrary or discriminatory enforcement of the statutes. Here, we have it very clear that a ringing telephone is easy to understand. The interruption of one's day and mental health is easy to understand. Drawing lines, trying to say how that repeating ring is being caused is confusing and is, I think, exactly what the legislature intended to avoid by leaving the statute as it is and just focusing on the harm caused to the recipient of the call. The focus of the statute is on the effect on the victim, not on the arbitrary channel used to have that effect. And we heard from Ms. Cool more eloquently than I could do in my writings about the intrusion that it has had and the effect that it's had on her through the Talking Parents app, both in those moments and over the course of many months. Frankly, and I said this in my response, the use of the Talking Parents app to conduct this harassment campaign, far from being some sort of way that responsibility can be avoided, the avoidance of using a conventional telephone call, that should be seen as an excuse. The use of Talking Parents should be instead be seen as a significant aggravator for this unlawful conduct, because the Talking Parents, of course, is a tool designed to create a safe channel of communication within the justice system when other methods have failed, and to see it used in this harassing way, to constantly ring the victim's phone in a way that interrupts her day and interrupts her peace and tranquility is exactly what I think the statute is intending to avoid. Very importantly, and I think goes to defense counsel's point, it's not the text contents themselves that are important, although that is helpful perhaps in using the language of 1F, which talks about no legitimate conversation ensuing. It's not the content of the text that is at issue, but rather the effect that it has on the phone of the victim. We heard very clearly what that effect was here. Talking Parents may be an electronic app, but is often and regularly used over a telephone. Mrs. Cool was using it that way when the defendant repeatedly caused her phone to ring, intruding on her peace of mind, and the alarm and harassment and annoyance that she felt at his actions demonstrate why such conduct should and is addressed by the plain terms and wording of the statute. As the defense counsel says, the wording is significant, and we take it as such. If nothing else, we should leave it for the jury to apply the facts to the wording in the statute in this case. But moving then to the 1E portion, the true threats portion, I'll just underline again the context of the series of text messages between 4 p.m. on January 29th, 2026 and 11 a.m. on January 30th. A string of accusatory messages about Mrs. Cool fucking another person, accusing Ms. Cool of driving by the defendant's house during a time when she was at work and not possibly doing so, and stating that the defendant was reporting her to her school supervisors. Mrs. Cool identified and talked about today the fact that she worried, and it did seem that the defendant was acting delusionally in these accusations. She repeatedly said, and you'll see in the exhibits, that the use of the Talking Parents as he was doing was highly inappropriate, asked him to please stop, asked repeatedly to be left alone. These are all messages that he ignored. Specifically then when he jumped at 10:20 and texted, "Where is your gun? This has gotten out of hand." She understood this message in the context of what she was going through in the middle of school to be a threat of violence against her. And 27 minutes later, asking about her departure from school, you heard how that both terrified her and how the effect that it had on law enforcement. We do believe that using counterman as a controlling authority, that these messages were sent in a manner that recklessly disregarded the likelihood.
Yo, I'm way more offended by his use of the than by his F-bomb.
That a recipient would take them as threats of bodily injury. Looking at the language in her location, which we presume Ms. Shoffitt understood from his other messages, his messages certainly meet that mens rea as required in counterman, and likely a higher one than recklessness.
Donald, just look at Twitch chat. She's been talking on Twitch chat on the screen.
We would invite under 1E the court to consider whether the statements of the defendant constitute a true threat under the First Amendment, or whether it's merely an intent to harass, which might be protected speech under Moreno. The speaker does not need to actually intend to carry out a threat. Rather, the focus is on protecting an individual from the fear of violence and the disruption that fear can engender, the possibility, as well as preventing the possibility that the threat and violence could occur. And that's at People v. Brown, 510 P3D 579 Colorado App 2022. the Supreme Court has found in counterman, as we said, the reckless mens rea is required, and the people must identify the speech that is objectively a true threat and must show the defendant acted at least recklessly as to the threatening character of the communication. We believe that in the context and the testimony offered today that we've certainly done so, and I don't believe the defense counsel has met his burden. Under Colorado law, to identify a true threat, this court should first consider the plain language of the words used. That's People v. Janicek, 871 P2D 1189, Colorado 1994, and I'll skip citations there in my brief further. If the speech contains a threat, then the trial court decides, given the context, whether the statements are true threats outside the First Amendment. To understand the question of plain language and context, the court can also look to People v. Chase, which is it was just cited in my brief, in my response. There it should explain how a court should examine the facts to understand the reaction of a reasonable person to an alleged threat. A threat is a statement of purpose or intent to cause injury or harm to the person, property, or rights of another by the commission of an unlawful act. The critical inquiry is whether the statement, viewed in the context in which they are written or spoken, constitute a true threat. And a true threat is not merely talk or jest. It is to be evaluated by whether those who hear and read the threat reasonably consider that an actual threat has been made. Well, whether a statement is a true threat is a question of fact to be determined by the fact finder. Of course, the court has an obligation for an independent review of the record. In this determination, we first consider the plain import of the words used. We must also consider the context in which the statements were made. Some of the contextual factors that may be considered include to whom the statement is communicated, the manner in which the statement is communicated, and the subjective reaction of the person. Here, obviously, the statement was made via an inappropriate medium directly at the threatened party in the context of a hostile, I think we heard it described, series of accusatory threats that evidenced what I believe the victim described as delusional statements by the defendant. And of course, the subjective reaction we heard from Ms. Kuhl, the immediate call to law enforcement, leaving her classroom in tears, trying to find a way to avoid her normal routines for fear of violence. The Supreme Court has also illuminated the issue of true threats and what type of statements can be criminalized in Virginia v. Black, cited by defense counsel. Intimidation and the intent to put people in fear is a true threat. The First Amendment permits a state to ban true threats, which encompass those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group. The speaker need not actually intend to carry out the threat. Rather, a prohibition on true threats protects individuals from the fear of violence and the disruption that fear engenders, as well as from the possibility that threatened violence will occur. Intimidation, in the constitutionally prescribed sense of the word, is a type of true threat, where a speaker directs a threat to a person with the intent of placing that person in fear of bodily harm or death. And later, the Supreme Court in 2015 in Alanis versus United States explained that the existence of the threat depends not simply on the mental state of the author, but also what that statement conveys to the person at the other end. But again, that recklessness standard is very important on the part of the defendant. Whether a statement is a true threat, again, is a fact-intensive exercise, and the court may consider the plain language itself, but also should look at whether the credibility of the threat is undermined in any way, and the recipient's subjective reaction, again, is of paramount importance. U.S. v. Wheeler, citation in the briefs. Here, the plain language, where is your gun? This has gotten out of hand. And then, are you at school today and not leaving without permission, as described in my response, has the implication of violence, the implication of a situation out of control, the location of the defendant, and a reference to her being controlled at that location. We've heard from the victim and from law enforcement that they immediately recognized it as a threat, and we agree that in the context at which it was offered, it was a threat, and any inability to recognize that threat when sending it certainly was reckless. Threats might be inferential. There are very few, I think, threats that are given out where the exact time, location, manner of the violence to be imparted are specifically referenced. I don't believe that that's necessary. Bomb threats rarely say when and where a bomb will go off. Merely the threat is enough to cause terror in a population. And of course, we heard a little bit about the follow-up conversation with the defendant, that although we didn't have the specific officer here, that what the defendant was expressing certainly evidence that he was making poor decisions at the time, or in a mindset where poor decisions could be made, just the type of mindset where violence can easily ensue from otherwise decent and good people. Lastly, we would just like to say that our bill of particulars specifically reserves in paragraph 3 that it is not a tool of full discovery, and we would object to the defense effort to bind us completely to 2 statements alone in that bill of particulars. But we did, we believe, fulfill the request of the court and the requirements of the bill of particulars in offering the statements that we are able to discuss today. Unless you have anything else, Your Honor, that's all I have.
Thank you.
Thank you.
Mr. Lex?
Yeah, brief reply, Judge. Thank you. I don't think the court is confused about the standard, but I do think some of the legal framework that was argued by my colleague from the prosecution can be confusing. Here's what I mean by that. Chase, which was the case that the prosecution cited, that's from 2013 when they're listing the factors. I don't know, I actually didn't see Alanis in my citation review. I don't know when that's from. In the Interest of RD is a case from 2020. Wheeler is a case, 10th Circuit case from 2015. So those standards that those cases are given, they are pre-Counterman. Counterman was from 2023. And so, and I'm not up here saying that context doesn't matter. What I am saying is that the analysis goes back to whether or not this constituted a true threat. And, you know, I guess one of the arguments that was made is like, well, a threat can have an undefined time period or manner of execution. I agree, but it still has to be a threat.
Hi, Alan.
And so the other statement that was made is like these, you know, these statements, these 2 statements identified by the people, they might require an inference to be a threat. Well, if it requires an inference to be a threat, then it's not unambiguous.
The
Right, and
lawyers
so-
are almost done. They're just almost done.
That's where I go back to when the court looks at the statements themselves. Are these a serious expression of a purpose to commit unlawful violence?
Absolutely,
And
yes.
did Mr. Shafet act with a mental state of at least recklessly concerning the threatening character
Absolutely,
of
yes.
the statements? Neither of those statements meet the threshold to be a true threat under 1E. And as far as, because I don't have too much to follow up on the 1F outside of, you know, my initial argument, but there's a difference between making a telephone call with no purpose of legitimate conversation and causing a telephone to ring repeatedly with no purpose of legitimate conversation, and what Mr. Shafet is accused of doing in this case, which is sending messages that may have an alert on them, but they do not fall under 1F. And as far as like the policy arguments go, Judge, like I think it's very clear that the legislature knows how to regulate speech that comes in other platforms, or not even speech, I guess, for 1F, to regulate, you know, communications or attempted communications that come in other platforms, because the legislature did do that when they amended 1E. And so I think there's a request made to the court to overexpand 1F. And, you know, we have, you know, legislatures that meet every year that are capable of drawing a more expansive statute if they believe one's appropriate. So I don't think it's the court's place to do that when we have a body that, you know, can make those amendments and has made those amendments. I don't think it's clear from the statute itself that applies. I think it is not covered by the statute itself, these type of communications. So that's my rebuttal, Judge.
Finally, now we hear the judge.
Did I just clarify
No, I'm
the
wrong.
citation that?
This
that
is
issue?
quick.
Thank you. Sorry, so defense counsel had said, Illinois, versus United States, that's at, 575 US 723, and it's in 2015. It's 2015 case.
Okay, thank you.
Yeah, it's cited in Counterman.
Yep, exactly. And Counterman, I should say, doesn't wipe out everything that comes before. I mean, all of those cases give, again, context is everything. You can make the statement, I'm going to shoot you tomorrow. And the context of that coming from a photographer versus coming from an ex partner who's put you in terror is completely different, and context matters.
How about
I'm gonna
let's do
a couple
shots
of
tomorrow?
things.
Shot.
As to count two, I'm going to go ahead and issue my ruling. And they're two separate motions, so I can do it that way. Because of the amendment, we ended up with the filing of the two motions since that we didn't have the two counts in the beginning. So in front of me today, I have the motion to dismiss count one for failure to state an offense and as unconstitutional as applied. That was filed March 21st of this year. And then the motion to dismiss amended count two as unconstitutional as applied, filed April 8th of 2026. I did hear the testimony of the witnesses, arguments of counsel. I've read the motion, response, and reply, and looked over the exhibits. I'll just tell you as to count one, I don't think I'm going to find anything, but I'm going to try to see if I can find anything that can help with that. I'm struggling a little bit. It's 189111 It says make a telephone call or causes a telephone to ring repeatedly, whether or not a conversation ensues with no purpose of legitimate conversation. When I read it all the way through with no purpose of legitimate conversation, it seems to me to be directed at phone calls where you'd actually have a conversation as opposed to a text or a note, something through an app where there's communication. And when I read 189111 it does reference communications, initiates communication with a person. So a part of me does believe that subsection F really is about phone calls and phones ringing. But just because I can't find anything specific, I just want to take a little bit more time with that piece. And I don't believe we can rely on Weeks. I don't have it right in front of me, but Weeks was from 1979. It references not being, oh, here it is. So that's 591 Pacific 2nd 91, Colorado Supreme Court case from 1979. It references it's impossible for the recipient of the phone call to know who's calling. Well, we've passed that, right? And so I don't think I can rely on that because that really was about that phone rings. You don't know who's on the other side. You've got to answer it. We are now in this technology where you can see who's calling or texting. You can turn off ringers. You can turn off the whole phone or just notifications for one thing. But
No, you
I
can't.
just need-
Not if you have children to take care. You can't. Like you just can't. Okay, when I was young, my mother was not available by phone whenever she didn't want to be available by phone. You know, because people didn't have phones with them all the time. But nowadays, if you have a child somewhere, you have to be available by phone. You don't get to choose to turn your phone off.
to spend a little more time with that. So that's why I'm struggling with that piece. With the motion on 189111, we're talking about true threats.
All right, guys.
It
If it's not fixed in 4 weeks, we are all going to chew out Brem. Feel free to use any swear word at him you want to 4 weeks from now.
is true that some of the case law talks about the perception of the recipient. But looking at Virginia versus Black, And we have that citation on the record. I think both parties have referred to that. I have it as one.
Bren, I hope you said Kathy said so, because that pulls weight with YouTube. You don't even know. They get scared.
23 Supreme Court 1536 from 2003. And then we have Counterman versus Colorado, another U.S. Supreme Court case, 600 U.S. 66 from 2023. So in Virginia versus Black, true threats are described as threats that encompass those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. In Counterman, citing to another case, it also references Virginia versus Black. And then I think it references Watts. It says true threats or serious expressions conveying that a speaker means to commit an act of unlawful violence. What we have before me today are two statements. And those statements, one is, where is your gun? This has gotten either out of hand or out of control. I'm sorry, I'm looking for my notes.
Out of hand, that's the grammar.
Pardon?
Out of hand.
Out of hand.
Tell them they owe
And
me a
then at some point, and I don't think anyone really identified how much time passed, there was some reference, and honestly, I don't understand it completely, where it talks about leaving without permission. So potentially implying that Mr. Shoffitt knew that Ms. Cole had not left as she normally does. Those do not convey a specific, a serious expression of an intent to commit an act of unlawful violence. Even if you say that's how it was interpreted, my interpretation is it doesn't meet the requirements of the statute. It's protected speech. It doesn't meet the definitions in the case. So I am dismissing count 2, as those are not threats of violence.
He won.
True threats of violence. And so it would
Yep,
be
he won.
attacking protected speech and
That's
therefore
protected speech.
unconstitutionalism. And count 1, I've got to the best of my ability, it might not be the correct answer, but I'll get you something. I've got to figure out when I can get you an answer, because I think
So he's allowed to just harass her all he wants because it's protected speech. All right. Now we're going to get into just legal questions about delusional versus competent. And then that's it.
Run into this issue a couple times where it's within 30 days despite income changes. I've had to be accepted sometimes. Sometimes they won't take one. So
Okay, then I'm just going to appoint the Office of the Public Defender.
Thank you, Judge. I'm in receipt of a 6-count complaint. I'll wait for the arraignment advisement. I'm asked to set an arraignment in about 30 days.
All right. And I have a notation that we need a weapons affidavit from Mr. Brown. And so, Mr. Brown, I've appointed the Office of the Public Defender to represent you. And so, Mr. Callahan and Ms. Bacher are here from their office today. If you have any questions about that form, they can help you with that. But we will need a completed form before you leave the courtroom today. And then we're going to set you for arraignment. Anything from the people
Maybe
today?
the judge will say, oh, sugar, once he shoots her. Maybe.
Yes, good morning, Your Honor. Madeline Ash appearing for the people. We do have the victim on WebEx. She is wishing to modify the protection order this morning.
Okay. All right. And let's see. Is there someone connected on WebEx for this case?
Yes, I am.
Okay. And is this Ms. Wardlow?
Yes.
All right. Ms. Wardlow, what is it that you wish to address today?
So Christopher is my full-time caregiver, and so he does daily activities, daily duties for me. He changes my catheter. and it was supposed to have been changed last Saturday, and it hasn't been changed yet because of the protection order.
Okay, protection order modified. Go ahead, sir. You're free to go. Change her catheter, please, for the love of God.
So I was just wondering if there's any possible way that we could get that lifted so that I could still get the care I need.
And what is the prosecution's response or position
They're
rather
fine
on
with it,
the
Judge.
request of Ms. Wardlow?
Your Honor, I have some concerns just given how recent the case was. It looks like the date of offense is May 7th, so there hasn't really been much of a cooling off period. But that being said, I don't believe we ended up filing any physical allegations, and it looks like the basis of this case is really just breaking into the home. And so for that reason, I am okay with lifting the no contact order and the vacate the home provisions.
All right. And Mr. Callahan, does Mr. Brown have any objection to that modification?
No, Judge.
Okay. All right. And so I've read the PC affidavit. I'm going to go ahead and modify the mandatory protection order in the case to lift the vacate the home and no contact provisions. And so what that means, Mr. Brown, is that
Thank you,
starting
Judge.
effective right now, you may have contact with Ms. Wardlow. You may be in the same place or the same home as she. What remains as part of the mandatory protection order is the provision that you have no harassing, intimidating, or retaliatory contact with her or with any other witness of the acts that you're charged with in this case. All the weapons restrictions remain as well. And those modifications are as to Ms. Wardlow. All right. And so do you have any questions about those modifications, sir?
No.
Okay. Then we're going to set an arraignment. June 8th at 10:30. That'll be in Division 18.
June 8th, 10:30 a.m., Judge. I go fill out the affidavit with him in the hallway, Judge.
All right. Thank you. All right. And do I have Anthony Casas here? Or Casillas? How
Nothing
about
crazy
Brandon
happens.
Cavazos?
Nothing crazy happens here. We're just going to hear a discussion with the lawyers.
Joseph Cruz Castro?
He is my client. He's in a courtroom somewhere. I'm just trying to figure out which one.
Okay, thank you.
I think I've shown this judge 3 times before total. Bobby would know better how many times I showed this judge.
So yeah, sorry. Okay.
I even named this clip No Dead Space because I went in and cut out all the dead air. And here we are listening to dead air right now. I'm not good at my job, guys.
Judge, can we call Joseph Cruz Castro?
Yes. All right, Mr. Cruz Castro is here with Mr. Newby. This is 26 CR 2058 that's set for first appearance today and 25 T 9043. Mr. Newby?
I have received a 7-count complaint information. I would waive reading and advisement and ask that we set, it looks like it is prelim eligible.
All right. And we will do that. My notes indicate that we need a weapons affidavit from Mr. Cruz Castro.
Okay.
And so if he could fill that out for us before he leaves the courtroom. And that's just in the felony case. Let's see. Anything from the people today? Okay. And we'll set a preliminary hearing in 26 CR 2058.
The way her eyebrows and forehead goes down, it looks like she's always very angry.
June 15th at 1:30. 18. Vision 18.
Yes, I will make that work.
I just
We're going to Division 18.
Yes.
should not
Okay.
have left
Yes.
any of this in here. I should have
All
cut
right.
this out.
Yes.
Are you stopping criminal?
Yes.
Why are you smiling so much? No, are you, what sort of law are you be?
Oh,
handling?
well, that was interesting. I'm glad I let that in. Maiko, did you hear that? June 15th. She's stopping criminal. That means maybe Judge Eric will come back to criminal. Look, that might be the time when they're switching judges around. Fingers crossed.
I'm swapping the criminal for civil docket.
Okay.
Will I see you?
No, Your Honor. But it's good to see you.
Yes.
Thank you. Appreciate
Yeah.
that. We'll,
Don't be a stranger.
we will. Thank you.
Okay.
My glasses are always on my head. Or lost. I don't know. They're not in front of me right now, so they're probably lost. Bobby must be getting coffee because he's not all over this.
Think I did. Yeah. Oh, yeah. He's the yeah. So I'm just gonna.
I'm going to lose my mind. I am going to bump it forward.
Do I have Anthony Casillas or Casas? Brandon Cavazos? All right. Is there anything else that we can call right now?
Not yet, Judge. I've got 3 VRA folks on the 9 a.m. docket,
Yeah.
so close. And also, we did just get a message from one of our Division C public defenders, and it sounds like Mr. Cavazos was down there,
Oh,
and he
I
got
see.
there at like 8:15, so he should be on his way up, and we'll be able to call him soon.
Okay, sounds good.
Sorry, guys. It looks like I made some major editing errors with this clip.
All right.
Sorry about that.
Great. Good morning. This is 26 CR 1936. You're Brandon Cavazos?
Yes, ma'am.
Okay.
Sorry about that.
I need an
That's all
editor.
right. We're set for first appearance. Let's see, Mr. Clopine, does the prosecution have a complaint to provide Mr. Cavazos in the case? All right, Mr. Cavazos, a complaint has been given to you by the prosecution this morning. That lists the charges that have been brought against you in this case. That's a 3-count complaint. What are your plans in terms of representation, sir?
I'm trying to get approved by the public defender's office, and it was up to your discretion, is what I was told.
Judge, he was over by $453.
Okay, well, I'm gonna appoint the Office of the Public Defender over their objection today.
All right, thank you. Thank you.
All right, and so, Ms. Bucker, how would you like to proceed today?
Judge, if we could set this out for an arraignment in about 3 to 4 weeks, just to give us time to get that discovery and speak with Mr. Cavazos.
Sure. Okay, I can set an arraignment date for Mr. Cavazos. It'll be a date in Division 18, so June 8th at 10:30 a.m.
Thank you, Judge.
Thank you. Thanks, sir. We'll see you then. Or
I had to salute the sergeant major.
It is 100,000% possible
She's the boss.
I cut out the clip and left the parts that I shouldn't have. And we're never going to see the clip because it's gone now. Deleted. I'm going to fast forward it a little bit.
I'm just waiting on supervisor approval to see if we'll be withdrawing from Mr. Rodriguez's case or another case. For that reason, I do want to make sure we set out a little bit, but I'll make sure to have that motion filed before the next court date if we're going to be withdrawing.
all right. All right. Is there any objection from the people to that course of action?
Your Honor.
June 8th at 10:30 for arraignment for Mr. Rodriguez, and that would be in Division 18.
Thank you.
Judge, if I could call a few other quick out of custodies before I run to the in custodies. I have Mr. Sordiff here as well.
No.
All right.
No. This is
For
wrong.
6-8 that has the warrant.
This is wrong.
There was a failure to litigate it.
Judge, Ms. McGrath did ask that I represent the court. She does wish to continue representing herself. I did advise her that because of the competency proceedings, the court would likely deny that request, but I am making that request on her behalf at this point. I'm not asking to withdraw.
I am absolutely going to start doing food, Monica, but not on court vibes because this is court. But okay, the problem is, here's the problem, the big problem. Might be insurmountable, the problem. I have this huge barn at my new place, humongous barn. And I wanted to put up like a fake kitchen in the corner because when the camera's on, you only need to see this much space. You know what I mean? No one will know it's not a real kitchen. Hot plate, crock pot, not air fryer. I don't like that. It doesn't taste good to me. But the internet, it's so rural. Where I'm moving is so rural that internet is sketchy, very sketchy. So in the home, I'll have the best I can get, which is not great. I don't know if I'm going to be able to get internet out to the barn, which sucked because I wanted to make it like barn, like some kind of farm cooking or barn or whatever. I just don't know if I can get the internet to go that far. So it might have to be in my kitchen. But I don't know. I'm definitely, because food is so yummy that I definitely am going to do something with food.
And Ms. McGrath, as I said before, I have concerns about your competency, and I believe that Colorado law really, if not requires me, strongly encourages me, although it might require me. There's some interpretations that I read in that way to make sure that you have counsel in place when your competency is being litigated. And part of it is that it remains to be seen whether in the
Sarah.
future the court finds
Thank
that
you,
you're
Holly.
capable
Thank you.
of making a knowing, intelligent, and voluntary waiver of your right to counsel. I do have those concerns right now about whether you're able to make a knowing, intelligent waiver of your right to counsel. And so, over your objection, counsel will be representing you at this time.
Judge, as to 26M2232, I'd ask the court to enter an outpatient order for an evaluation. I believe a mental health study was already entered though, and held off on the actual order. I'd ask to reset both cases to past July 10th for receipt of the eval. And then this is an issue that I don't think I've had come up before. Does the court intend on communicating directly with the evaluator in the same way that attorneys do after competency is raised? Does the court believe it can?
No, I never have. I think that the order that's on file explained the reasons the court raised competency. And so I certainly would encourage the prosecution or the defense, when contacted by the evaluator, to share that order so that they have some understanding of why competency was raised.
Thank you, Judge.
And so let's see, I'll certainly order an out of custody evaluation in 26M2.
They're just going to schedule next. Nothing happens. I missed the clip. I kept a dead air. That's what happens when I have a stream and then I have another stream 6 hours later. I get sloppy. Sorry, guys. Thank you, though, for coming out. I really, really, really appreciate it. Tomorrow, I'll make sure I keep in the court cases and cut out the stuff that is supposed to be cut out. I hope you guys have a great day today, even though it's Monday. Try to make it the best Monday ever. And I will see you guys Tuesday. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.